Hello, this is Matt on the Moon Lambo channel, and it is finally over, the day that we've all been waiting for. Ever since XRP received its legal clarity in July of last year, we've been waiting for the conclusion of the remedies phase of the lawsuit, which is the literal end of this lawsuit. Now, of course, there could be an appeal. Maybe Ripple will appeal, maybe the SEC will appeal, maybe both of them, right? But that would be a separate case. This one's over. This one is absolutely at the district court level, 100% over, and Ripple's really happy with the results here. They really should be, and they are. I'll just tell you this at the outset. $125 million penalty for Ripple, which may sound like a lot, but not if you factor in what the SEC was actually asking for, which is frankly completely outrageous, and I didn't think there was a chance in hell that was going to happen, and it didn't. Based on everything seen to this point and everything that I've read from various lawyers within the XRP community, this does not damage in any sort of material way Ripple's business model. There are a couple things that could make it a little bit more annoying to conduct business with a cryptocurrency as a bridge currency in a corridor touching the United States, but is that something that's going to cripple Ripple's business? No, certainly, absolutely not. I've got opinion from Brad Garlinghouse in commentary, also Stuart, Alder, Ripple's chief legal officer, and 4 attorneys within the XRP community. Unfortunately, even though it's been a few hours since this news broke, unfortunately, I haven't seen any public commentary from Attorney John Deaton. I was hoping to have something from him publicly stated before I record this video, but, he is running for Senate in Massachusetts, so might be a little busy right now, so he gets a pass on that one. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Shout out and credit to Attorney James K. Filan. The final shout out to Attorney Filan in this case. He has just been on top of this for years. Every single time there was something filed in this lawsuit, he was out there keeping the entire community informed. I can't tell you how much I appreciate him, and I know the rest of you all feel the same, but this is the final one from him in this lawsuit. And it wasn't that long. I mean, probably about half the damn thing was, as is frequently the case with these documents, just kind of background of the case itself. And I was very curious to see the stuff about ODL, which we are going to talk about a fair bit in this video, but suffice it to say, as I alluded at the outset of the video, it's not going to be a problem. It just isn't. Here's a post from Ripple CEO Brad Garlinghouse about an hour or so after the news broke. The SEC asked for $2 billion, and the court reduced their demand by 94%, recognizing that they had overplayed their hand. We respect the court's decision and have clarity to continue growing our company. This is a victory for Ripple, the industry, and the rule of law. The SEC's headwinds against the whole of the XRP community are gone. Golf clap for Brad Garlinghouse right there. Absolutely, that's correct. And it's kind of ridiculous. So fine, they have to pay this penalty, and of course, not surprisingly, way smaller than what those asshat pricks at the SEC were saying would have been just. But I'd like to remind you that there were no Ripple customers that were harmed, and there's still this massive penalty, almost 4 years of headache. Folks, do you realize another several months, it would literally be 4 years since this stupid-ass lawsuit was filed, and there weren't any actual customers that were victims, and there's this penalty. It's just completely absurd. But here we are with XRP having legal clarity in a freaking bull market. That's what we want. Oh, and by the way, so I'm not going to talk much about XRP price in this video, but I'd be remiss if I didn't state XRP did move up a little bit. Nothing too exciting here. I mean, because, the price of XRP in July of last year when it got legal clarity, in about 4 hours, the price of XRP doubled. In this case, XRP price, from the time the news broke, went up a little over 20% from 50 cents to almost 64 cents, which is a key resistance area, and it's been falling back now, and it's 59 cents at the time that I record this. So I think this is pretty clear evidence that most people understood what I've been saying on the channel, which is that XRP already has legal clarity. It's like you can't, it doesn't need anything else. Whatever happens in the remedies phase of the Ripple lawsuit, while interesting because we've all been here for a year, well, many of us have been here for years, it's interesting, but does it make a difference to the typical XRP holder? No. And so some people clearly don't know that, and people got exuberant, and we're in a bull market, and so the price went up a little bit, but not that much, and I don't know that this is going to be sustained to the upside. I mean, I don't know, maybe, but I'm kind of skeptical. Like, I always kind of figured the bigger deal would have been when it received legal clarity, and that lasted for several hours. This was more of a whimper compared to that, which I think makes much more logical sense. And the volume did skyrocket. It was a little shy of $1.2 billion, which is pretty normal for any given XRP period, and it rocketed to almost 3.8 billion. So, or I guess a little over that at one point, and then back down a little bit to this point. But, we already had the legal clarity. Who cares? All we need to wait here, we don't need anything else. We just need to wait for the, not as XRP holders anyway, we just need to wait for the market itself to rebound and for alt season to ensue, and XRP, you better believe, is going to be a part of it when this thing blasts off. That's my belief anyway. Here's a post from Stuart Alder, Ripple's chief legal officer. He reposted what I just shared with you from Brad Garlinghouse, and he wrote the following. A final judgment. The court rejects the SEC's suggestion that Ripple acted recklessly, and she reminds the SEC that this case did not involve any allegations of fraud or intentional wrongdoing, and no one suffered any financial harm. She rejects the SEC's absurd demand for $2 billion in fines and penalties. We respect the $125 million fine the court has imposed for certain historic sales to sophisticated third parties. Yeah, and also note, although of course, I don't know for sure what the balance sheet looks like for Ripple, but the last time Brad Garlinghouse talked about this, he stated that Ripple had over $1 billion in the bank. So this isn't exactly a problem for them. They can write a check for this immediately. Not a problem. They don't need to sell a bunch more XRP either. Nothing like that. This is a very good ruling for Ripple. And by the way, I'll note that attorney Jeremy Hogan, he's pretty close actually. He was predicting for funsies, that Ripple's ultimate penalty would be $100 million. So it was a little bit higher than that, but he was pretty damn close actually. Speaking of attorney Hogan, here is what he had to say upon the news breaking a few hours ago. It's over. The SEC v. Ripple case has been quite a journey. Thanks for sharing it with me. $125 million penalty and a generic injunction order. This is a big win for Ripple, no doubt about it. Have a wonderful day. Yeah, so generic injunction order having to do with sales, which in theory could and would, to whatever degree, impact ODL, but it's not something that's going to stop them. And I've got more coming up on that, but Ripple already has like, this is the status quo in a way. It's like Ripple has already changed what they've been doing as it pertains to on-demand liquidity using XRP as a bridge currency, which is to say they haven't been using it in any quarter touching the United States, but the rest of the world, does it matter? I'll share with you the perspective, but let me do this in an order here. I want to share with you next what attorney... actually, let me share with you the screen grab from attorney Hogan. And they are talking about ODL here. This is from the judge in the ruling today. Ripple also argues that Part 2 of the proposed judgment, which enjoins it from conducting an unregistered offering of institutional sales, proposed judgment at 3, should be altered to clarify that it does not bar ODL sales, does not bar extraterritorial conduct, and does not bar sales that qualify for exemptions from registration. The court agrees that the SEC's proposed language is too categorical and, in any case, duplicative of behavior prescribed by Part 1 of the proposed judgment. The court will, therefore, omit the SEC's proposed Part 2. Right. So the part that could have been more damaging to Ripple's business model and perhaps more XRP specific, it doesn't exist. And so right there, citing, this doesn't apply to the rest of the world. Extraterritorial conduct, which is what I was pointing out several months ago when there was all this hubbub. There's wide discussion in our community about how this, depending on what happens in the remedies phase, it could just completely blow up, Ripple's business as it pertains to on-demand liquidity. And I said, no, it won't. Because that's not how law works. I'm not a lawyer. I just play one on YouTube. But that's not how this works. In other geographic regions, they can do whatever the hell they want. It's under completely different management. And so that's clearly the case here. Here's what attorney Fred Rispoli had to say. Overall, huge win for Ripple. Although I'm surprised that with the $125 million hit, Ripple more than made that just on the price move in XRP in the last 5 minutes. Here are the major takeaways from the ruling. Current sales of XRP post-complaint do not necessarily violate federal law. That battle is for another day, meaning a new lawsuit. Oh God, I hope there's not a new lawsuit. There could be though. I won't be surprised at all if either side does decide to appeal, for example. But there could also be a brand new lawsuit outside of this. Anyway, then he says, I called that the judge would essentially grant an injunction that Ripple could not violate federal law. That's where we leave it. SEC lost bigly where the court refused to grant a categorical injunction on all institutional sales, especially on ODL. No disgorgement. Huge loss for SEC here. Ripple did not recklessly disregard regulatory requirements. Post-July 13th conduct by Ripple, re institutional sales, did not rise to level of blame shifting. I called NetBurn expert rule was never going to be decided in a way favorable to Ripple. Today starts the 60-day countdown is what he means, to the deadline to file an appeal. So if there's going to be an appeal, we got a couple months. We're going to find out inside of that time period if that's indeed going to happen. But the SEC, now that it's all done, you can see they got almost nothing they wanted. Yeah, there's a penalty that's way more money than pretty much any human's ever going to see in their lifetime, $125 million. But that's nothing for a company like Ripple. It's not a big deal. There's a recognition that there was no fraud. No actual human, no customer of Ripple's was actually harmed here. The people who got harmed were the everyday XRP holders because the market, understandably, was freaking out when the SEC lawsuit dropped, and there's a lot of uncertainty as to what it meant. The SEC caused way more damage to typical investors than Ripple ever did. Ripple didn't cause any damage. Ripple's just fine. And so it's just amazing to see the degree to which this is a stunning defeat for the XEP. It's just, you can't even overstate it. And we knew that in July of last year, but this is just the cherry on top. Like, this is, to see it ended this way, fine, $125 million penalty, whatever. There's no disgorgement. This isn't going to ruin their business model. Everything's fine. There's this post from attorney James Murphy, aka Metal Lawman. Judge Torres has issued her ruling on remedies in Ripple. $0 disgorgement, as expected because no losses shown by the SEC. 2, $125 million in civil penalty for securities violations and sales to institutions. 3, injunction restraining Ripple from further violations of Section 5 of the Securities Act. This is a small fraction of the damages the SEC was seeking in the case. My guess is both sides will appeal. Yep, I won't be surprised at all if that's indeed the case, but, isn't a funny thing too? So $0 disgorgement, again, because nobody was freaking harmed. Remember one of these stupid ass arguments the SEC was making, which is that certain customers got sweetheart deals. So there were like volume purchasing options. And then the SEC was trying to note that that was pecuniary harm as a result. It's the biggest BS argument. And I'm not going to read through the whole thing, but I remember reading, there was somewhere in this, 16-page document, that's actually cited, and she's like, yeah, that's not a good argument. I'm paraphrasing, but that's effectively what was stated by Judge Torres. And I was like, yeah, I know. Now, as far as ODL, let's talk about this, because we already knew, we found this out several months ago. Ripple is using XRP in ODL in all corridors in the around the world that aren't the United States. XRP is still being used. Now, it's not being used in any corridor touching the United States. Tether's being used currently. Now, of course, with Ripple launching their own stablecoin, I'm thinking that's going to shift. But look, here's one example of a headline at the time, April 24th of this year. Why Ripple decided to replace XRP with USDT for US clients. And I don't need to read the article. I was just highlighting this as a refresher. And I'm sure most of you are aware of that news. I mean, again, it's several months old at this point. But that's why I was like, okay, well, when this thing concludes, this won't change anything for Ripple. If it comes down to it, they can just keep using Tether for any corridor touching the United States. And that's stupid, but if that's what's necessary, they'll make that determination. We'll find out. Okay, it doesn't ruin their business model. Nothing gets worse, right? It gets better because we have legal clarity, at least 100% legal clarity. Sans some sort of appeal, but still, we're going to go here. And then XRP continues to be used everywhere else, and the vast majority of ODL transactions were always occurring outside of the United States. So this is not a problem. Here's a post from attorney Jeremy Hogan specifically on this. He says, I see lots of questions, re what the injunction means for ODL sales. I don't see it changing the status quo at all for the following reasons. Number one, as Ripple stated, the majority of its XRP and ODL sales are outside the U.S. jurisdiction and not subject to the ruling. Those have and can continue. Folks, I was screaming that in April this year. Everything is going to be fine. In fact, so my recollection, and I hadn't thought about it much over the last several months once the topic died down in our community, but I mean, there's a company, it's like a sister company of Ripple effectively, and they wholly manage what happens with on-demand liquidity. So that's where the sales are happening. It's not Ripple in the United States. It's technically, legally, a different company. Judge Torres can't rule over that. That's not how international law works. I know that from college, okay? Like, there's no power to stop that. So that was the good news. That's why I already knew, like, if people are thinking that we're going to get some, majorly important thing to develop in the remedies phase to the typical XRP holder, I said, no, we're not. Even if it's bad news for Ripple, I was like, it's not going to matter. It just isn't. This is one use case. It impacts a tiny percentage of Ripple's transactions for that particular use case. There's a big ass community out there. There's a lot of projects being built on the XRP ledger. It wouldn't do anything. It wouldn't ruin XRP's future. Wouldn't ruin long-term viability, no matter how bad this got. And it actually turns out isn't that bad. Okay, and then he says, number 2, Ripple can sell XRP to institutions as long as it sells it under an exemption to registration. There are like 5 major exemptions, and it's much easier to fit into an exemption when selling to a business. I can think of 2 viable options off the top of my head. So there you go. XRP can be used or can be sold on an institutional level, presumably, perhaps even for ODL. Although I am wondering still, I need some additional clarity on this, admittedly. I don't know to what degree that's going to cause additional friction and then just kind of ruin like what makes this technology makes possible. So I can't speak to everything, but again, this all just happened in the last few hours. There will be more to report on in the future. Number 3, the judge didn't give the SEC the ODL language it wanted, and therefore, if the SEC feels Ripple has violated the order, it would have to move for contempt and present evidence of the violation. This would allow Ripple to then raise its argument that there can be no expectation of profits when the XRP is only held for a second, which is a winning argument to me. Yeah, and so I do still think that, Judge Torres' rationale on programmatic sales makes sense. On the institutional side, when when the ruling broke in July of last year, I was like, ooh, that's pretty stupid. I don't agree with Judge Torres' particular ruling there. I don't see how it could satisfy the Howey test when clearly none of these transactions are being held with the expectation of profit. It doesn't compute to me, but is what it is. Number 4, Ripple's legal team has had the summary judgment ruling for over a year now, and I can guarantee they have changed how they sell XRP in order to comply. Whether they got too close to the line, as the judge says, would be something we'll only know if there is a contempt hearing. Yeah, and so I did read that in the final ruling here, the remedies phase of the lawsuit. She did say that there's reason to think that Ripple, basically getting so close to the line, actually probably would cross it at some point, and so that's why the injunction was included at all in this. But it wasn't the language that the SEC wanted, so it was basically watered down in comparison, but the judge gave them little something technically. Again, it's not something that's going to ruin the business model. And then Hogan says, there might be a couple of other things I'm forgetting, but I have a nasty fever right now, and that's all I can think of. Summary, I think Ripple will be able to use its ODL product. It will just have to be careful how it does it. But it's been that way since July last year. Exactly. That's what nothing changes. So I think he's spot on here. And I hope you feel better out there, Attorney Hogan. You're a champ, though, for taking up your time to report this analysis, especially while not feeling so hot. Much appreciated, good sir. And by the way, I'll make this full screen here. I'm not going to read this. This is from the ruling here, but just for the sake of time. But if you want to, this is what Attorney Hogan shared. Somebody also wrote to him named Prosperity Fund and said, Attorney Hogan, even if true, why didn't Ripple file these exemptions years ago? It seems either they would not likely be accepted, or even if they did, having their business labeled a security would lead to business complications for their use cases. And Attorney Hogan said, good question. The exemptions are a pain to comply with, require disclosures to the buyer, and, to be honest, I feel Ripple, the company up until 2018 or so, was a little footloose with things, and even though they had lawyers telling them they were probably okay taking the easy path, they was wrong. Yeah, and fair enough perspective. I just still I'm still wondering, this is what I don't have an answer about, admittedly. I'm wondering to what degree, even if they did that, does it damage the business model, that aspect of their business model? If there are all these things that you must comply with, does it render the technology in some capacity, useless or less useful? And I don't have the answer for that. But the point is to remove friction and have effectively real-time transactions. And if you have to file a bunch of paperwork, what's that look like? Can it be automatically streamlined so that it wouldn't matter? And that, admittedly, I just don't have the answer for you on. But either way, this isn't something that, like that much I know, this does not cripple their business, not even remotely. I mean, Ripple's celebrating. You think Ripple would know if this were really bad for them? They are celebrating. They're very happy with this. Attorney Morgan read Attorney Hogan's perspective having to do with on-demand liquidity, and here's what Attorney Bill Morgan had to say. I agree. Attorney Hogan summed it up very well. Having to fit ODL sales into an exemption or register sales are limitations on the possibility of very cheap global liquidity, cheap global second long ODL transactions when the sales by their nature are not securities. The vision was for the instant transfer of value at virtually no cost, as the internet allows the instant transfer of information. Why does a national regulator need to interfere with that? Fear with what the technology makes possible for the whole world? Yeah, good question. And they shouldn't be, very obviously, but this is where we're at right now. Everything's still fine despite this, though. So that's the good news. There's also this post from Attorney Morgan. Look at the injunction that was made. U.S. institutions going to do ODL business in the U.S. with that injunction in place? Why would they take that risk? And so here's the screen grab. And again, I'm not going to read it just for the purposes of time. And I'll just say that, I don't think anything has materially changed. And so this is a bit of speculation from me, because I can't know for sure what Ripple's thinking, of course. But I don't think this changes much of anything compared to where Ripple was in July of last year. And Ripple does have customers, despite the ambiguity leading up to this point, to whatever that would be. They still had customers using on-demand liquidity. It's just that they weren't using XRP. So I'm not seeing, if this somehow changes that, that's not the perspective that I'm seeing from any attorneys out there. So, if he's asking here, why would anyone do business with Ripple with this language here? And I'm like, well, why would they stop? Like, I don't see the argument as to why they would stop just specifically because of this language. Now, I'm open-minded if there's something that's going to damage it. But even if that's the case, understand XRP already wasn't getting used in the United States. You can't make it extra not get used in the United States. So I don't think it matters for the typical XRP holders. So even if that were bad for Ripple, which somebody would need to prove to me, nothing gets worse for the XRP holder is what I'm saying. This doesn't matter to us as XRP holders, and that's what I'm most interested in, and that's what I most care about. Now, I don't like the SEC damaging a business that is a great cheerleader for XRP and the XRP ecosystem, Ripple, but what I most care about is the XRP community broadly speaking. And yes, of course, Ripple's part of that, but I'm thinking about the typical XRP holder, because the XRP holder, they're the ones that have really gotten the snot knocked out of them, especially with the SEC lawsuit getting filed in the first place. It just financially ruined all sorts of people. At least Ripple has a veritable war chest financially, so they're going to be fine. Here's another post from Attorney Morgan. He reposted something from my fellow XRP YouTuber Jungle Inc. Jungle Inc. said, how could a company IPO when a judge just blasted their entire business model? Well, to be clear, the judge did not blast their entire business model. In fact, Ripple has substantially expanded away from just being a payments company and utilizing XRP as a bridge currency. I mean, they're launching a stablecoin, so now they're a stablecoin company. That on its own is its own business, but they're doing that. They bought out Medico, so they're getting into custody. They're trying to be the enterprise solution company for all businesses. The judge clearly did not blast their entire business model. And also, as it pertains to the aspect of their business that is on-demand liquidity, XRP can and will continue to be used as a bridge currency the world over, except for, presumably, in corridors touching the United States, unless they can find some neat way around it. So I'm not seeing this as a negative. Not particular. Like, this isn't something that's going to ruin anything for Ripple, as I keep saying. But, Attorney Morgan reposted that and said, Ripple's current arrangements for ODL sales, according to the evidence, are structured, I believe, on the assumption the injunction would be made. They sell through overseas subsidiaries and to accredited investors. ODL sales in the U.S. do not use XRP. The business model for 4 years has been based on Ripple being frozen from ODL sales in the U.S. Right. So nothing got worse because of this. There's legal clarity for us as XRP holders. Right. Somebody also wrote to Attorney Hogan named Mickey D and said, another question, Jeremy. The SEC have 60 days to appeal by Sunday, 6 October, which, knowing them, they will. Yawn. What are they likely to appeal against, and do they stand much chance of getting anything from appealing Could it go to the Second Circuit? Attorney Hogan says they have the right to appeal, and if they do, the focus will be on the programmatic sales for sure. So that's the part that matters to us. The good news is, first of all, they're on the wrong side of history, so even if they try and do this, that's not going to work. Won't be surprised to see if there's new leadership at the SEC at some point throughout the rest of the process, so it could get thrown out anyway, even if they move forward here. And also, by the time there are any sort of conclusion, if there was an appeal, and if we saw it to fruition, that's another several years out. And then that can get appealed, whatever, depending on what happens there. So, like, this is going to be well past the bull run. We're good to go. Like, we're fine here, folks. Now, of course, XRP didn't have some crazy spike, which I'm in a way happy to see. I mean, I'd like to see price of XRP go higher, but in terms of rational behavior, this is much more rational than could have occurred. There are some people that got a little exuberant about it. Maybe they don't understand that XRP already has legal clarity. So yes, happy to see XRP price higher, but this isn't, it just doesn't matter. It just does, like, we already had our clarity in July of last year. We're good to go. I'm just more excited to see the bull market take off. So we'll keep watching this, but cool, man, right? Like, so that's it. This is it. It's over. Thank you, everybody out there, so much for all the support over the years, as I tirelessly reported on this over a span of years, pretending to be a lawyer all up on the YouTubes. I very genuinely appreciate all the support. And so it's kind of wild for this to slowly sink in that this is actually over, at least this portion. I mean, the lawsuit itself is over, completely over. Now, there can be an appeal, but this lawsuit itself, it's over. That's it. That's all she wrote. That's amazing. Like, after almost 4 years of riding this train, man, we can all hop off. Now, we may have to jump on a separate chain if there's an appeal, but we'll cross that bridge when and if we get to it, right? This is really cool to see. This is really good stuff. So thank you so much, very genuinely, from the bottom of my heart, for all the support out there. I mean, I know it's been stressful for so many people, but we made it. We're better for it. We're out on the other side. We're going into a bull. Well, we're in a bull market. There's so much to be thankful and happy about. So, one hell of a community. We are one. I will argue. I always have, and I will continue to do so. Just argue. The XRP community is the best community in all of crypto. I stand by that, and we have proven it over the years, and we've gone through a lot together. So, thank you again. I'll just wrap it up there. You guys tell me what you think. Please drop some comments below. I'd certainly love to hear from you, but I will wrap up. There's going to be more to say in the coming days and weeks, especially if there's appeal. But this is where we're at right now. We pretty much got what we wanted because we're on the right side of history, and you'll love to see it. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.